Good morning to everybody and welcome to our webinar titled How to Protect Your Trade Secrets in China. This webinar is organized jointly by the China IP SME Helpdesk and the Flanders China Chamber of Commerce EU-China Business Association. My name is Peter Siegel and I will be your moderator for today. I am a project executive at the China IP SME Helpdesk, and I would first like to present you to the tool that we're using for the webinar, GoToWebinar. Not sure if you have used it already. I'm assuming that in these COVID times, we all use a bit more of these tools than we normally would. What is important is that you can ask questions with the questions pane in the GoToWebinar panel. And during the Q&A session, these questions will be answered by the speakers. So please don't hesitate to ask any questions during the whole webinar using this pane, and then we will get back to them during the Q&A session. Please allow me to say a few words about our project, the China IP SME Helpdesk. We're an EU-funded project by the European Commission, and our mission is to provide legal advice, intellectual property-related advice to European companies wishing to do business in China. Our main service is a free inquiry helpline through which European companies can get in touch with us, and our IP experts will answer any IP-related inquiries in a free and confidential manner in 3 working days. And we often organize training workshops and webinars. Now, for the last almost 1.5 years, it's been webinars. We really hope to get back to real-life workshops as well once the pandemic is over. We also maintain our own website and blog where you can find recordings of the webinars and all kinds of resources related to intellectual property in China. We have business guides for your enterprise. We have fact sheets for your enterprise. We have various tools that you can make good use of in exploring the intellectual property scene in China and getting legal advice for your business activities. You can see here a few examples of our fact sheets and business guides. These are very well-designed, business-friendly documents that are really meant to help companies without complicated legal jargon and really in a business-friendly way. So you're more than welcome to consult our website and download these guides, and also to get back in touch with us directly via email, and we'll be happy to send you the most appropriate guides for your specific sector or industry. And then without further ado, I would like to introduce our speakers for today. Firstly, we have Ms. Gwen Song, the Executive Director of the Flanders China Chamber of Commerce and the EU-China Business Association. And we have Mr. Valentin Delacour, who is the IP expert for the China IP SME Helpdesk, and also the head of the China desk at Delta Wolf. So after this small introduction to the webinar and to the China IP SME Helpdesk, I would give the floor to Ms. Gwen Song, and afterwards I will give the floor to Mr. Valentin Delacour, who will present a longer presentation about protecting your trade secrets in China. And as I mentioned already, the last 15 minutes of the webinar will be a Q&A session. Please feel free to ask any questions that you might have using the questions pane, and then we will get back to these questions later. So then, Gwen, I would like to give you the floor. Please let me know when you're ready to start, and I will move the slides for you.
Okay, thank you, Peter. So I will start now. Ladies and gentlemen, good morning. On behalf of the Flanders China Chamber of Commerce and the EU-China Business Association, I would like to warmly welcome you to our 6th joint webinar with the China IPR SME Helpdesk. It will be a pleasure to listen also to our member, Mr. Valentin Delacour, who is the IP expert at the IPR SME Helpdesk. As a chamber, we attach a lot of importance on IP, and we think that companies doing business with China should also have an IP strategy included in their China business plan. China has become already a leader in innovation in several areas, such as the internet industry and artificial intelligence. And a majority of European companies also said that Chinese firms were equally or even more innovative than European firms. Speaking about innovation and speed, this morning, I was surprised to read in our Chamber's weekly business newsletter that in Beijing, shops, restaurants, and communities have signs showing the inoculation rate of the inhabitants or employees. And in Beijing, already 50% of the population has been vaccinated, and the aim is to go to 70%, which is the threshold for herd immunity by the end of May. I think this is something we could only dream of. Don't know when this will ever happen, but so as a result of this speed of the vaccination campaign, and of course the efficient tracing, and so the Chinese, according to the IMF, the Chinese growth will be at 8.4% this year, which is the highest in 10 years. And also foreign investment in China have increased by 6.2%. China overtook the US and regained the title of the world's top destination for FDI, and will also be one of the main drivers of growth this year. More business opportunities will also rise as the EU-China investment agreement has in principle been signed last year. The EU-China Comprehensive Agreement on Investment is the most ambitious agreement that China has ever concluded with a third country. It will offer broader market access and a better business environment for investors in Europe and in China. European companies active in manufacturing industries such as cars, traditional and new energy vehicles, production of transport and health equipment, and production of chemicals, amongst others, will see new business opportunities. There will also be further opening up in the services sector, such as financial services, telecom, private health service, and so on. Let me say a few words about the Flanders China Chamber of Commerce, as you can see on the slide. Our chamber was founded by the largest investors from Belgium and China, such as Ageas, Agfa, Bekaert, Barco, Picanol, Umicore, and so on. And our aim is to help Belgian companies expand in China and to assist Chinese companies in Belgium. We provide a weekly China business newsletter to keep you up to date on China's economy and trade. We organize webinars on how to and how not to do business with China and give expert advice. Normally, we also receive many Chinese delegations that we can introduce to you, but we hope to be able to do this maybe in the second half of this year. We are also active on the European level. We are in charge of the EU-China Business Association, which is the association of all bilateral China business associations in the EU, aiming at promoting the economic and trade relations between the EU and China. I would like to keep it short and would like to mention that we are at your disposal for any further information, and we also welcome you for an online talk, how we can further assist you with your business with China. Thank you.
Thank you very much, Gwen. And then without further ado, I would like to give the floor to Valentin. As I mentioned already, Valentin is our long-standing IP expert with the China IP SME Helpdesk. He is also the head of the China desk at Delta Wolf. So he's a real expert on trade secrets in particular and intellectual property in general in China. So Valentin, then I would like to give you the floor. I will also make you the presenter, so you will be able to control the slides and share your screen. And you are supposed to have control over the screen now. Valentin, I think you're muted. Maybe you can try to mute yourself.
So can you see the slides?
Yes, and I can also hear you now.
Okay, perfect. Are the slides moving?
Yes.
Okay, perfect. Well, hello everyone. I'm very happy to be here and to have the coming half an hour to talk about trade secret protection in China. First, well, I would like to thank the FCCC for organizing these events. Thanks to Gwen for the great organization. And there are plenty of attendees, so it's I'm very happy to be here today. to talk about this important topic, trade secret protection in China. So trade secrets in China, well, it's definitely a hot topic for several reasons. Maybe the first one is that trade secrets are used nowadays to protect highly valuable information. Typical example, the world's most valuable resource is no longer oil, it's data. How do you protect data? Well, through trade secrets and confidentiality. Second reason why it is a hot topic, well, nowadays hardly a week goes by without having press reports regarding alleged trade secret thefts by Chinese individuals, by Chinese state-sponsored hackers, by Chinese employees. Trade secrets have been a key argument in the allegations made by the Trump administration against China regarding IP theft. They have a prominent part in the trade agreement that was concluded in January 2021 between the US and China. So there's also a political dimension to trade secrets when it comes to China. And last but not least, and I will elaborate this a bit further, a bit later on, we have witnessed these last year a very intense legislative dynamism when it comes to trade secret protection. This is true in the US, this is true in Europe, and this is certainly true when it comes to China. But before entering into the details of the Chinese trade secret protection regime, I would like to say a few words on the context of trade secret and trade secret protection. First thing that is important to mention, it's not a school, but we evolve nowadays in a knowledge-based and information-based, ever more digitized economy. And when you look at this graph, well, it's interesting to see that if you take the S&P 500, the most best performing companies in the world, and if you look at the intangible assets and the value they represented in 1975, well, intangible assets accounted for 70% of corporate value. 45 years later, intangible assets constitute 90% of corporate value of the best performing companies in the world. So intangible assets are playing a key role in today's economy. And what gives a value to a company nowadays? Well, it's really its capacity to innovate and its capacity to appropriate, to control, to exploit, to monetize the result of its innovation. Now, how do you do that? Well, the law provides you with two important tools to manage the results of your innovation. First, intellectual property rights, trademark, patents, copyrights, design rights. These are the best known IP rights. What is an IP right? Basically, it's an exclusive right, a monopoly that is granted on the object of the rights. First tool. Second tool, trade secrets. Now, trade secrets are not intellectual property rights, so no exclusive right is granted. Trade secrets protect you against unlawful acts, unlawful access, disclosure, exploitation of confidential information. So to make you understand this difference, which is very important to understand what a trade secret is, let's look very briefly and on a high level approach at what a patent is. A patent protects an invention, which is a technical solution to a technical problem. And a patent is an exclusive right that is granted for an invention. So what is an exclusive right? What it enables the patent holder to exclude others from making, using, offering for sale, selling the invention, object of the patent, without its authorization. So if you develop, let's say, an innovative technology to save the battery life of a smartphone, if that invention is new, is inventive, if you get a patent on that invention, well, no one will be able to exploit or will have the right to exploit that invention without your authorization. Now, what is very important with a patent is that it is public information. Anyone who's a bit familiar with patent law knows that patents are available in patent registers. And so when Uber, for example, announces that they have filed patents on virtual reality systems for self-driving cars, if you know where to look at, well, in a few clicks, you have access to the patents. And you have access to the invention, the background of the invention, the prior art, and also what is claimed, what the invention exactly is and what the scope of protection exactly is. So a patent, and it's the whole idea of patents, you make your invention available and known to the public. In return, you get a monopoly and exclusive right for a limited term. Of course, trade secrets, well, they function in a totally different way, because the main characteristic of a trade secret is that it is confidential, it is secret. Okay, so no exclusive right is granted. The protection of a trade secret is mainly a factual protection. It will depend on the nature of the information and the way that information is handled. Basically, you need to proactively protect the secrecy of the information, because once it is known, well, it's a known fact, and you're not protected anymore. Anyone can have access to that information. You lose your competitive advantage that you had through the confidentiality of a specific information. An interesting thing regarding trade secrets is that it can cover a wide variety of information. I will come back to this, but it's not only technical information like an patented invention, technical know-how. It can also cover commercial and financial information like cost price data, consumer lists, consumer profiles. These may qualify as trade secrets and be protected. But so remember this fundamental difference between IP rights, exclusive rights, trade secrets, protection against unlawful acts. Now, they're different, but it doesn't mean they cannot work together. On the contrary, trade secrets and IP rights are complementary, and they're both used by innovative European firms that use patents and trade secrets to protect the results of their innovation. And a report that was published a few years ago confirmed that trade secrets were even more used than patents to protect innovation of European firms. And this is true across all member states, in most economic sectors, and for most types of companies. So from startups to SMEs to multinationals, trade secrets play a key role in managing the result and protecting the result of their innovation and protecting their competitive advantage. Now, important to know that risks related to trade secrets have only increased over the years. Trade secrets thefts are on the rise. And why is that? Well, basically because there is an increased flow of information nowadays. And this is due to several factors. Of course, internet and digitalization. So easy nowadays to copy in a few clicks thousands of documents and to make them available to the world over the internet. Another important factor is open innovation. Nowadays, companies innovate through collaboration. They don't innovate by themselves. They work with research institutes, universities, clients, partners, even competitors. And when you innovate together, well, you need to share information, you generate information, and there's a risk that you may lose control on that information. Globalization of supply chains plays also an important role, certainly when it comes to China. If you have some key technological components that you have manufactured in China, well, you will need to share sensitive technical information with your Chinese manufacturer. Again, there's a risk that you lose control over that sensitive information. Mobility of workers, extremely important when it comes to trade secrets. Nowadays, people do not do their whole career in one single company. They go from one job to the other, especially true in China, where you have a high employee turnover, especially for good employees, talented employees that are difficult to retain. And very often, well, it's exactly the type of employees that have access to sensitive information. And every time an employee leaves your company, well, there is a risk that he will leave the company with sensitive confidential information. And then hacking, also a risk, especially in these COVID-19 times and the home working that we're all doing. Now, important to know is that when it comes to trade secrets and risks, the biggest risk is not hackers. It's really people that are close to the business. So employees, ex-employees, business partners. And when you look at statistics in the US, in Europe, in China, well, you realize that trade secret cases are the very high majority of these cases are between people that know each other, companies and, for example, employees or ex-employees. So we've seen that trade secrets play a key role in today's economy. They're important to the value of a company. There are increased risks related to trade secrets. So next question, well, how do you protect your trade secrets? If you approach this question from a very high level point of view, trade secrets require basically protection requires basically two things. You need a good law. You need legal tools to enable you to protect and enforce your trade secret rights. So you need an appropriate legal framework. Second thing, you need to do your homework and you need to have an internal strategy for the management and the protection of your trade secrets. So if you look at the legal framework, it's very interesting to see that over the last years, we have witnessed a global awareness on the need to reinforce the protection of trade secrets. And this has translated in the adoption of new legal acts in the major economies around the globe. It's true in the US, it's true in the EU, where the Trade Secret Directive was adopted in June 2016. The Trade Secret Directive was transposed into Belgian law in July 2018. So we have a fairly new trade secret protection regime in Belgium. And in China, it's also true. The Anti-Unfair Competition law was revised in 2017, and 2 years later in 2019. And as we will see in 2020, important legal texts were adopted that have a direct impact on the protection on the protection regime of trade secrets in China. So bottom line, we have an improved legal framework in all the major economies around the globe, including in China. But as I mentioned, the law is not enough. You need to have an internal trade secret management and protection strategy. You need to do your homework, because basically protecting your trade secrets can only be done if you're proactive. If you take the time to understand what your trade secrets are, and that you adopt confidentiality measures to protect the secrecy of that information. And what we witness is that most of the companies, especially smaller ones, especially SMEs, well, they lack a clear internal trade secret management and protection strategy. And just ask yourself a few questions regarding your own situation. Does your company perform trade secrets and IP audits? Do you have a trade secret inventory? Do you actively manage access to your trade secrets? Do you implement a trade secret awareness policy within your organization? Do you involve HR in the protection of your trade secrets? Do you monitor the use of your trade secrets and enforce your trade secrets if you spot an unlawful act? If the answer to this question is yes, well, that is perfect. If the answer is no, well, then you may be at risk, and probably you have to undertake some actions in order to mitigate these risks and to better protect your valuable confidential information. So very important, keep this in mind, have a trade secret action plan. This is true for the protection of your trade secret in Europe and certainly in China. And this is usually the path that I take my clients through. Start with an audit, establish an inventory, improve the protection measures in place, educate your people, and then monitor the use and protection of your trade secrets and react if needed. So let's focus now on the trade secret protection regime in China. And to start with, quick look at the legal framework. Won't be too long here, but important to know that you have one law that is really the centerpiece of the protection of trade secret in China. It is the Anti-Unfair Competition law. This law was recently revised in 2017 and 2019, but we also have a set of other laws and regulations that can have an impact. The contract law, company law, labor law, criminal law, may have an impact on the protection of trade secret and may help you build legal arguments if you're facing trade secrets misappropriation. As I mentioned, also recent trade secret legislative dynamism, especially in September and November last year, where important rules where draft of trade secret protection rules were published and some interpretations were adopted by the Supreme People's Courts. And all these texts relate to the enforcement of trade secret through the administrative, civil, and criminal routes. But so what does this mean? It means that in China, there's a clear will, political will, to strengthen the trade secret protection and enforcement environments. And this is, of course, good news for Chinese companies, but also for foreign businesses like you. So the centerpiece is the Article 9 of the entire Fair Competition Law. In yellow, you can see all the recent additions and modifications of that important article. What do you need to remember? Basically 3 things. First, the definition of trade secret has been broadened. So more information may qualify as trade secret because now Article 9 clearly refers to all commercial information, so it's not limited to technical and business information. Second, there's an expanded scope of trade secret misappropriations, so more acts can qualify today as misappropriation and will give you the ability to react and to enforce your rights. Article 9 now explicitly refers to hacking, refers to electronic intrusion, and refers also to indirect infringements. So basically, it's nowadays possible to invoke the liability of those that contribute or induce others to commit trade secret theft. And this, of course, directly has a direct importance to be able to act against, for example, new employers of an ex-employee. You have an employee that leaves with trade secrets. He's employed by a competitor that's employed him with this in mind, have access to your trade secrets. Well, you will have the possibility to act against the ex-employee, but also against his ex-employer. So that's an important and interesting addition. 3, clarification of who is liable for misappropriation. Basically, more people may be held liable because under the previous regime, the legal text was limited to business operators, and now with the new Article 9, it also includes individuals, legal persons, and non-legal organizations. And so under the previous regime, you had a whole discussion, well, can employee as individual person be held liable of trade secret thefts? There was some ambiguity here. All this ambiguity is removed, and you clearly can target individuals, and so employees, ex-business employees, consultants, business partners, individually. So 3 important additions: more information qualify as trade secrets, more acts qualify as misappropriation, and more people may be held liable. Now, another very important text I will refer to is the Supreme People's Court judicial interpretation that was adopted in September 2020. What are these interpretations? Well, basically, the official interpretation provided by the Supreme People's Court, which is the highest judicial court in China. And well, they provide some guidance on the application of certain laws, and these interpretations have legal binding force. So it's almost like law. And here, when it comes to trade secrets, the judicial interpretation is very interesting because it provides guidance to courts on how to analyze trade secret infringement cases, how Chinese judges need to reason to approach trade secret infringement cases, but also it provides guidance to companies, businesses like yours, on how to protect their trade secrets. And we will see you have some very concrete clarifications and, in a certain way, advices that are given by the Supreme Courts in order to protect trade secrets in China. So that's it for the legal framework. Let's now focus on the definition of a trade secret. It's very important if you want to protect your trade secret, to understand what a trade secret is. How can you protect something that you don't understand, that you're not aware of? It's common sense, but it's not that easy. And so it's very important to go through the exact definition of what trade secrets are, and it's a work that you will have to do if you want to protect your trade secrets in China, is to identify your trade secrets, and if needed, will improve the protection measures that are in place. So what is a trade secret under Chinese law? Well, if you look at Article 9 of the Entire and Fair Competition Law, it says that a trade secret is commercial information that are not known to the public, that have commercial value, and for which reasonable efforts to maintain secrecy have been made by the right holder. Now, it's interesting because if you look at the definition that is provided in the European directive, you basically have roughly the same approach. A trade secret is information that is secret, that has commercial value because it is secret, and you need to be able that you have adopted reasonable steps to keep that information secret. So 3 components, 3 requirements to have a trade secret. First of all, you need information. We will see it's an open notion, covers undisclosed know-how, business and technical information. And you need to be able to evidence, to prove that the information is secret, not known to the public, that the information has commercial value because it is secret, and that you have proactively protected the secrecy of that information, that you have adopted and undertaken reasonable efforts to maintain the secrecy. This is really important. So let's focus on these 4 requirements. First requirement, information. The law says and refers to commercial information such as technical information, business information, and etc. So it's a broad and open notion that goes from algorithms to data sets to consumer profiles to manufacturing processes. Very open. Now, interesting to have a look at what the Supreme People Court says about this, because they clearly identify typical information that may qualify as a trade secrets. And they focus on the one hand, technical information, so information in relation to technology. And the Supreme People Court says, well, it can be information concerning the structure, raw materials, components, formulas, materials, samples, patterns, processes, algorithms, data, computer programs. So you see that a lot of information is tackled here, of technical information is tackled here, and it's confirmed by the Chinese Supreme People's Court that this type of information may qualify as a trade secret. Same for business operation information, where the court clarifies that it's information concerning creativity, management, sales, marketing, financing, planning, samples, bidding materials, customer information, data. So bottom line, well, close to any kind of information may in theory qualify as a trade secret, provided of course that you can establish that the other conditions are met. So if you undertake the work to identify the trade secrets within your organization, what do you have to do? Well, you need to identify this type of information, and then you need to assess whether it meets the other conditions. Requirement number 2, of course, secrecy and confidentiality. We're talking about trade secrets, so information that is not known to the public. And again, if you look at the Supreme People Court's judicial interpretation, it says that it is information that is not widely known and not easily accessible to those relevant in the field when the alleged infringement act occurs. Those that are familiar with the definition given of confidentiality under EU law will know that it's pretty close. And so the ease of access to the information is really the key criteria to assess whether information is confidential or not. Further guidance is provided by the judicial interpretation. Interesting to know is that they clearly say that any new information formed by sorting out, perfecting, and processing information that is known can qualify as confidential information. So if you take known information and by assembling it, by improving it, by processing it, you arrive to you reach new information that will qualify as confidential information. Important also to know that will not qualify as information, well, obviously information of general knowledge, but also information that is directly available to those relevant in the field by observing the marketed product. And this is a clear reference to reverse engineering. If you can buy a product, you disassemble it, you understand how it works, well, all the information that you can derive from observing the product will not be deemed as confidential. Important also, it's obvious, but information that is made public through public presentation and exhibitions will not qualify as confidential information. For those of you who participate to trade fairs in China, be of course very careful not to disclose your trade secrets during these kind of public events. So the questions to ask yourself, once you identify information that you believe is important and valuable to your organization, you need to assess secrecy. And so you have to list new information that is not generally known, not readily accessible, that has not been made public. And it's a very concrete analysis that you have to make. Requirement number 3, once you identify the information, you assess the confidentiality. Well, you have to assess the commercial value of that information. And what does the law says and the judicial interpretation? Well, it's information that has practical or potential market value because it is not known to the public, because it is secret. So it's a broad notion. You need to be able to assess that the information at stake provides you a competitive advantage because it is secret, and potential value is in theory enough. The judicial interpretation is very clear: practical or potential market value. And again, a parallel can be made with the European directive that also refers to actual or potential commercial value of the information. So what questions should you ask yourself? Well, commercial value, does the information bring any economic benefit to my business? Would my business be hurt if the information is leaked? And the type of evidence that may be provided is, for example, sales invoices showing that the use of the trade secret generates profits. But again, I insist, potential value should be enough. So sales invoices is not a must, but of course, if you can bring them, that will help. So now that you have identified the information, assess the confidentiality, assess the commercial value, the last requirement, which is extremely important, is the adoption of reasonable steps to protect the secrecy of the information. Basically remember that trade secret protection is not an automatic protection. You have to proactively protect the secrecy of the information, and very important, you need to document this protection. Because if you want to enforce your trade secret, you will have to prove that information qualifies as a trade secret. You will need to be able to prove that you proactively adopted measures to protect the secrecy. So Chinese law refers to information for which reasonable efforts to maintain secrecy have been made. The judicial interpretation also refers to reasonable confidentiality measures to prevent trade secrets leakage before the alleged infringing act occurs. So bottom line, if you don't adopt protection measures, information will not qualify as a trade secret. What does that mean? You won't be protected. You won't be able to rely on the trade secret protection regime that is organized by law. And it's basically the first thing a judge will check. You want to enforce a patent, for example, a judge will check, is the patent delivered? Did you pay your annuities? Is the patent enforced in China? Yes, okay, let's have a look at your case. Trade secret, same thing. A judge will focus on the proactive measures that you undertook. You will have to convince him that you adopted measures to prevent what happens, to prevent the unlawful access, disclosure, use of your trade secrets. And again, here it's interesting to have a look at the judicial interpretation that provides some guidance here, because, and this is very important, there is no one-size-fits-all set of measures. The measures need to be reasonable, and that means that they depend on the circumstances. A judge will not expect the same level of protection and confidentiality measures from a startup as from a multinational. They will not expect the same set of measures to be adopted for information that is not that important, that has commercial value, but it's not key to the business, versus information that is absolutely critical to your competitive advantage. So no one size fits all. This needs to be reasonable. And again, the judicial interpretation provides guidance. A judge will look at the nature of the career of the trade secret, will look at the importance of the commercial value, will look at how identifiable the confidential nature was, etc., etc. So what reasonable steps to implement? Again, here the judicial interpretation is very interesting because it refers to a set of different measures. It refers to contracts, so the use of legal protection measures, NDAs typically, confidentiality clauses in your agreements. Second, it refers to training and regulations, so it's highly advisable to have a confidentiality policy within your organization and to train your employees, consultants, business partners on the measures that are in place to protect your trade secrets. The interpretation refers to physical barriers, so restricting visitor access to, for example, factories or part of the factories and workshops. Access management is absolutely key. IT measures, HR management, very important to, for example, if you have an employee that leaves your company, to remind him his confidentiality obligation, to make sure that he has returned, he has destroyed all the confidential information that was in his possession. And 7, important, other reasonable measures of confidentiality. So again, it's an open notion. The judicial interpretation provides very useful guidance, but they don't pretend to have identified everything that can be validly used to protect the confidentiality of trade secrets. So what reasonable steps to undertake? And this is valid for Europe as well, actually, which is interesting. It's valid for Europe and for China. A company-wide confidentiality policy, as I mentioned, access control, very important to restrict to a need-to-know basis. The more people have access to your sensitive information, the higher the risk. Common sense. Use contracts. Organize protection measures such as, well, the labeling of information as being confidential. Physical security, adapt your HR policy is very important to provide regular trainings, as I mentioned, but also to organize entry and exit briefings of your Chinese employees. You have a new Chinese employee, well, explain him the trade secret measures that are in place, explaining what is a trade secret, what he can and cannot do with that information. And then when an employee leaves, very important to remind him his obligations. Typically, I work with my clients on different checklists and processes that you put in place in order to make sure that that you organize these entry and exit briefings appropriately. And then last but not least, IT security. This is something that has been published by the UK National Cyber Security Center, and it's totally valid also for China, very useful, accessible on the internet. I can send it to you if you're interested. So again, what are the questions that you need to ask yourself? You identified important information, assess the confidentiality, assess the commercial value. Well, the last questions that you need to ask yourself is, what are the confidentiality measures that are implemented within my organization? And keep in mind that having an NDA is a good start, it's an absolute must, but it's not enough. So identify your trade secrets, manage access, and implement legal, physical, organizational, and IT security measures. And again, I insist, document these confidentiality measures, because if you need to enforce your trade secrets, well, you will have to prove that you've adopted all these measures. So very quickly, because I'm running out of time, a few words on enforcing trade secrets in China. Clearly, it remains a challenge, but any trade secret case is challenging. It's true in Belgium, in Europe, but it's certainly true in China. So what is a trade secret infringement? Remember, trade secrets law protects you against unlawful acts. And again, Article 9 of the Unfair Competition Law provides a definition of what is an unlawful act. Well, it's basically unlawfully obtaining trade secrets through theft, bribery, fraud, coercion, electronic intrusion, so hacking, or other improper means. It's an open notion. Disclosing, using, and allowing others to use trade secrets that were illegally obtained. And then the second degree infringer, if you know or should have known that information that you're using has been illegally acquired and lawfully acquired, well, you may also be held liable of trade secret infringement. So this tackles clearly new employers, very useful, but also risky. So when you hire new Chinese employees, well, make sure that they don't pollute your organization, they don't pollute your R&D or sales departments with trade secrets of their former employees, because if they do, there is a risk that you may be held liable of trade secrets infringements. Second, what remedies are in place? There are several routes to enforce trade secrets in China: administrative routes, criminal enforcement, where basically the infringer may be fined and sentenced to pay damages, and then the civil enforcement, where you can go to a judge and ask for an injunction, so in order to stop using and exploiting your trade secrets, and you can get compensated. And the system has improved recently because the statutory damages, the maximum statutory damages, have been increased to 5 million RMB, close to 650,000 euro. You now have specialized IP courts in China in charge of technical matters, including trade secret cases. So you have judges that are very professional, that can be helped by technical advisors that depend from the courts, which gives them really the possibility to understand the technology, understand the trade secrets at stake, and they render good judgments. And then fairly recently, we now have in China an IP division of the Supreme People's Courts in charge of important appeals of technology cases, and this gives a more harmonized case law when it comes to trade secret cases. So again, these fairly recent evolutions clearly indicate a will to improve the trade secrets protection environment in China. However, enforcement remains difficult. The main difficulty is the evidence. So as a plaintiff, and it's the same in Belgium, you have to prove what you allege. So if you want to file a case against an employee that left your companies with trade secrets, you will have to prove that the information at stake qualifies as trade secret, information, secret, commercial value, reasonable measures to protect secrecy. And you will have to prove the misappropriation. So you will need to prove this unauthorized use, disclosure, and acquisition. You'll need to prove the access to the information, which very often can be quite challenging. With the new revision of the entire unfair competition law, there's a new limit reverse burden of proof in civil litigation. So if you can provide reasonable proof that the defendant had access to the information and that he is using substantially the same information as your trade secret, well, the judge may reverse the burden of proof, and it's the defendant that will need to prove that he is basically not infringing your trade secrets. So that is an interesting addition. The win rate when it comes to trade secret litigation is fairly low, but it's difficult to assess because less statistics and numbers are published when it comes to trade secret cases compared to trademark, patents, copyright cases in China. But the win rate is lower. And yeah, recent legislative changes, as I explained, are a positive signal, but of course, independent of how it is practically enforced by the judges. So this remains to be seen. An interesting signal has been sent very recently with a judgment that was rendered by the Supreme People's Courts end of February this year, so a month and a half ago, with the highest ever damages for a trade secret case that were awarded, close to 20 million euro. So it of course fits with the whole narrative of China. We're doing the maximum to improve trade secret protection in China. We will see whether this is confirmed on the longer run and in most cases, but clearly it's an interesting and a strong signal that misappropriating trade secrets in China can have very serious consequences. So that's it. Last two slides to conclude. What should you remember from my presentation? Well, obviously trade secrets are widely used by companies. They're often the crown jewels of a company. Very often what has value in view of Chinese competitors, for example. Remember that trade secret enforcement is challenging, but if you want to succeed and mitigate the risks, important to take proactive measures to protect the secrecy, to document all the transfers of document information, document the protection measures, identify and document your trade secrets. Pay special attention to employees and business partners. It's true basically everywhere, but certainly in China. Prevention is key. You need to proactively manage your trade secrets if you want to be protected. Positive legal changes recently with a clear indication that there is a will to improve the trade secret protection environment. But let's see what the effect of this is in practice. And last but not least, well, important to define and to implement your trade secret action plan. So make an audit of your trade secrets, establish an inventory, improve the protection measures in place, educate your people, monitor the use of your trade secrets, and react if you spot any unlawful use, disclosure, access of your trade secrets. That's it. Thank you very much for your attention. And if you have any questions, well, I'm certainly happy to answer them.
Thank you very much, Valentin. We have collected a few questions during the webinar, and I would like to again encourage the audience to send us questions using the questions pane, or also please feel free to send us any questions after the webinar using the question@china-iprhelpdesk.eu email address that you also see on the slide. The first question that we got from Mr. Joachim Hakma, chairman of the EU CBA: when your patent is registered in detail, you might feel protected, but on the other hand, your patented product or inventions are more easily copied. How do you see that, and how could this be improved in terms of protection?
Well, basically, when it comes to technology, usually you have a double component. You have patents, and it's true. Patent, as I explained in my introduction, is public information. It's the whole idea of the patent system. You disclose your invention, so you enrich the technical and scientific knowledge, and everyone can have access, understand the invention, and maybe do a turnaround or improve or learn from your invention. But on the other hand, you have a monopoly on that invention, which is a very strong right, an exclusive right. Now, always important to remember is that patents are territorial rights. So if you want to be protected in China, well, you need to apply for patent protection in China, and develop your patent portfolio. Important to know that the win rate for patent litigation in China is very high. That foreigners usually obtain very good results when it comes to enforcing patents in China, and so patents are a really good tool to protect your innovation. Now, very often in your technology, you will have a patent, but around it, you have a whole set of information that you want to keep for yourself, that you want to keep secrets, confidential, and here, well, trade secrets play a key role. And so typically, if you license technology, for example, to a Chinese partner, to I don't know, to develop that technology and access the Chinese market, you will have double components. License will cover the technology, license will cover the know-how, but then you have to take a whole set of measures to clearly identify, protect, and try to retain the maximum control possible on the know-how you share with a Chinese licensee. Don't know if that answered the question. It's a very broad and open question. I don't hear you.
Apologies. Mr. Hakma, if you have any follow-up questions, then please feel free to type them in the questions pane. In the meantime, another question from Mr. Chris Myers. He says that the company he works for is considering to establish a manufacturing line in China. The operation of this line is completely based on trade secrets. So it's good to hear that China is making advances on their trade secret legal framework. But it seems to him that actually investing in China is based on trust. So the question is, will the Chinese government enforce their laws in favor of foreign businesses, especially considering that the Chinese government and business life are so interwoven? Do you have any experience with such cases?
Well, definitely challenging not to have any patents and to transfer the whole know-how to a manufacturing plant in China. So you will have to work on structuring that in a clever way to mitigate the risk and try to keep maximum control of the trade secret you transfer to China. In terms of enforcement, as I just mentioned, for patents, the win rates, at least for patents, there I've had access to numbers. The win rate is good for foreign businesses, and you don't have. I mean, the rule is that there is no local protectionism. The exception is that you have. So basically, as a foreign business, you will be protected, but you can always have exceptions depending on the importance of the adverse party in the area where you will file your litigation case. So it's important to play with jurisdiction rules and try to bring the case outside of the sphere of influence of the infringer. If it comes to very high strategically important technologies, you may also have some interference coming from above, but again, this is more exceptional. But again, as I mentioned, enforcing trade secrets is challenging, and you really need to have a good strategy and take all the preventive measures possible to avoid any problem from happening. And that may be a problem, but no choice. You have to do it. But if you do what is required by law, you definitely mitigate the risks of having problem when you have to enforce them.
Thank you, Valentin. Another question we have from Mr. Jorkan Bunnan is how much an early stage tech company building their presence in China should invest in their IP protection in China, both in terms of time and money?
Well, definitely you have to take China into account. Again, it's a bit an abstract question. Depends on the importance of IP. Depends on the importance of IP on the protection of the value of your business. If a patent is absolutely key to your competitive advantage, well, yeah, you have to invest in patent protection in China. Same for trade secrets, software protection. You have to take the relevant measures. It's a very tough environment where to do business. Loads of Western businesses are taken by surprise, sometimes by things that are only normal in China. Again, it's a tough environment, and not only for foreign businesses, for Chinese businesses as well. Very competitive. So if you want to have any chance to protect your competitive advantage, I mean, yeah, you have to invest. If you don't, and if your technology has any value in the Chinese market, you need to assume that it will be taken. One thing that I always mention to my clients and when I give webinars is not investing in IP protection in China. It's like giving a free license to use your technology, your trademark, to businesses that are active in China. So if you have a technology, you have a patent, if you don't apply for patent protection in China, it means that you are giving a free license to use your technology to your Chinese competitors. You won't have an exclusive right, you won't be protected, the information will be in the invention will be in the public domain in China, and anyone will have the right to use it. That's how the patent system works, not only in China, everywhere. But so you need really to approach it that way. Do you want to enable anyone to use your technology? If the answer is no, you need to invest in protection.
Well, thank you very much, Valentin. Thank you very much, Gwen, also for your presentation and for co-organizing this webinar with us. We reached 11:30. So we will have to stop here.
Yeah, well,
Sorry,
like
Valentin?
just to add one thing. I'm giving next week, if people want to investigate a bit further, another webinar on trade secret protection in China. I'm doing that's what the Chinese lawyer will be too, and we will analyze some case law. So if companies are interested, I'm happy to share the link. Yeah, that's it.
I will be happy to include it in the follow-up email as well, if you can share it.
Okay, good. I will send it to you.
Okay, so thank you very much again. The presentation and the recording will be shared with everybody. We will send a follow-up email possibly tomorrow. And all the questions that we could not answer due to time constraints, we will get back to you and answer them via email. Please feel free to write us to the email address that you see on the screen. And yes, you will be hearing from us very soon with responses for your questions. So thank you very much again. And we're looking forward to seeing you next time as well.
Thank you.
Bye.
Bye-bye.